For more than 27 years, the ACLJ has been fighting for freedom and liberty in the United States and around the globe. Chief Counsel Jay Sekulow has argued 12 times before the United States Supreme Court, including several landmark cases protecting religious and constitutional freedoms. The ACLJ is active in the courts, in Congress, and in the public arena.
And joining me now is Jay Sekulow, the Chief Counsel for the American Center for Law and Justice.
The Jay Sekulow Live radio program reaches over 1,000 stations nationwide and streams live on Facebook to more than 4 million users daily. With a weekly TV program and an active social media presence, the ACLJ has created a powerful media strategy to continue the fight for freedom and liberty.
Nearly 300,000 people in 2 weeks. If we can do that in a couple of weeks, imagine what we can do in 6 months. Imagine what we can do in a year. Imagine what we can do if we stand together.
Your support makes a critical difference. So thank you for joining with us. Thank you for standing with us as we seek to proclaim freedom and liberty here in the United States and around the globe.
Live from Washington, D.C., Jay Sekulow Live. Phone lines are open for your questions right now. And now, Chief Counsel for the American Center for Law and Justice, Jay Sekulow.
Hi, everybody. Welcome to the broadcast. Well, the Supreme Court just moments ago heard oral arguments in a case called National Institute for Family and Life Advocates versus Becerra. That is, Becerra is the Attorney General for California. National Institute of Family and Life Advocates is a pro-life crisis pregnancy center, and the case was argued, as I said, just the arguments just finished up a little while ago. Our friend Mike Ferris from the Alliance Defending Freedom argued the case. It's important to us, both on the substance, is that we defend pro-life pregnancy centers around the country, but also because of this, Living Well Medical Center versus Becerra. This is a case that is the identical issue of this compelled speech. The crisis pregnancy centers having to refer out for abortions and post these signs under what they call the FAIR Act. So we have a case pending this. So whatever happens in this particular case, in the case National Institute of Family and Life Advocates, impacts our case directly. Walter Weber is a senior counsel with the ACLJ, does a lot of our Supreme Court practice. He just left the Supreme Court moments ago. Walter, we talked before we went on the air. You're encouraged.
Yes, I'm very encouraged, Jay. The questioning indicated that the justices understood very well what was happening here and that this was an attempt to basically burden the speech of pro-life pregnancy centers in California.
Well, the FAIR Act, Jordan, is something we've been concerned about for a long time, because the FACT Act, as it's called, because it mandates compelled speech.
That's right. What we are concerned about here, we've talked about it a lot on this broadcast, is these state laws that have tried to force pro-life pregnancy centers. Some people know them as crisis pregnancy centers. They operate in every state across the country. So in some blue states where there are pro-abortion organizations donate a lot of money to specific campaigns, especially to those like attorney generals and governors. And so in a state like California, where the state leadership is blue, they have enacted through their state legislature these laws to force pro-life pregnancy centers. Basically, I mean, the easiest way to say this is to advertise for abortion services or be shut down. So literally say, hey, we don't provide abortions. Here's where you can go get one. Literally tell people where to go.
Yeah, the penalty is $1,000 per subsequent violation, $500 the first time. Walter, we got about a minute and 20 seconds here. Give us your sense of what's at stake here for the pro-life movement.
Sure. Well, one of the main themes that came out in the argument, Jay, the word we kept hearing again and again were gerrymandered and targeted. And I think what was at stake here was, is it possible for a state under the Constitution to target a pro-life center that it doesn't like and impose on it burdensome regulations that it doesn't impose on other people? And just pretty much everybody on the court was concerned about that. Across the political spectrum, they were all saying, this looks suspicious, this looks like a gerrymander, this looks like targeted. The state's attorney even admitted that they were targeting pro-life centers. So I think this is potentially a very important point. If the Supreme Court says you can't do that, that's really helpful, because then that knocks out a lot of what groups like NARAL and Planned Parenthood do, which is try and target not everybody, but just the pro-life centers.
All right, Walter, we appreciate your comments on this. Let me just let everybody know the FACT Act compels even licensed facilities to provide pregnancy services services to say there are public programs that provide immediate, free, or low-cost access to abortion. So it's requiring the pro-life center to refer for abortions. All right, we've got a lot more ahead on this discussion on the life issue. More from the Supreme Court of the United States. We'll be back with more in just a moment. Supreme Court of the United States just heard oral arguments in a case called National Institute for Family and Life Advocates versus Becerra. It is a case involving pro-life pregnancy centers that serve the needs of women in crisis pregnancy situations, and we've litigated these cases all over the country. We actually have a case that is pending this case right now. Our friend Mike Ferris has been a friend of mine, a lawyer, great lawyer, been a friend of mine for, probably 30 years, argued the case today representing the Alliance Defending Freedom, ADF, and the ACLJ has a companion case called Living Well Medical Clinic versus Becerra, same defendant. That case is being held. So whatever happens in the case involving National Institute for Family and Life Advocates will directly impact our case. Walter Weber is a senior counsel at the ACLJ. And Walter, let me again ask you right now, there were the licensed pregnancy centers and the unlicensed, but it was this compelled speech issue that was such a big deal.
Right. Both kinds of centers are compelled to speak. The licensed centers were required to advertise the availability of abortion at free or low cost, which is obviously totally incompatible with their pro-life views. The unlicensed clinics were required to include a disclaimer basically saying that they don't provide medical services, which sounds fairly non-controversial, but they were required to put it in the same size font as the ad. So Justice Kennedy asked, well, what if the ad just says choose life? And one of the other justices says, what if it just said pro-life? Well, then you've got that plus 45 words of the same size font. You basically are crowding out the pro-life center's ad. And even Justice Ginsburg and Sotomayor, who you think would be most sympathetic to the other side, said that's burdensome. And they all saw that as being a major burden. One example was brought up by one of the advocates, I think it was Mike Farris, said, what if you had an ad for a car company, and you got Chevrolet, and then you got 45 words of disclaimer in the same size font? They just don't do things that way.
Right. Logan, let's go ahead and take a phone call or a comment, whatever you like.
Let's go to Gina in San Diego, California. You're on the air.
Hey, Gina, go ahead.
Hi there. I just wanted to know if pro-choice organizations are required to give information about alternatives to abortion.
So in other words, does Planned Parenthood have to put up a sign that says, in essence, if you want to have an alternative to abortion, go see these free services available at these crisis pregnancy centers? The answer, of course, to that is no, and that shows the nature of what this is. As Walter mentioned and Jordan discussed, it is targeted speech at a particular viewpoint. That's what this is. It's viewpoint discrimination at the top of it.
Yeah, and we know, Planned Parenthood's not supposed to be forcing anyone, and their facility's not supposed to be forcing anyone who comes there to have an abortion. But we have heard time and time again firsthand accounts from women who have called into this broadcast and said, you walk in there, if you're pregnant, with the idea of what to do with this pregnancy, the first idea is abortion, and it's very difficult to get out the door without having that procedure performed because the pressure put on you. Again, those come in from firsthand account from women who call into this radio broadcast, but they certainly don't have to be putting up advertising. So again, it goes to that abortion distortion that we talk about. Yep. Abortion industry thinks that they should be treated differently than everyone else, and then so you can tell the pro-lifers, hey, you've got to advertise for us, and we don't have to do anything for you.
Yeah, Walter, let me play for you a comment from the president of NARAL. This was a comment she made in 2015, in October of 2015. Take a listen.
This is not about freedom of speech. It's not about freedom to worship however anyone chooses to worship. What it is about setting a baseline threshold of what people that are licensed or what licensed health facilities are required to offer to their candidates.
So, Walter, she starts with the proposition, this is not about freedom of speech, which is precisely what this is about.
Right. Well, that just means they're not taking free speech into account. When you were reading that quotation, I'm reminded of one of the questions that Justice Kagan asked, which was, and I quote, what was the state thinking? And her point was, you claim to have these concerns about informed consent and about making sure services are available, but then you look at the exceptions and you look at the exemptions, and everybody seems to be carved out except the pro-life centers. How can that be anything other than essentially a targeted attempt to try and put a heavy hand on the pro-life centers?
Well, I think this is exactly what it is. And what you have to understand is that they are targeting with a compelled message. which is a message contrary to the pro-life message. In other words, here's where you get your abortions. And by the way, they're low cost or free. And then they turn it around, and I think the caller's question was great. Well, that was, do they tell the Planned Parenthood clinics to put up a sign that says where you can get an alternative to abortion? And, of course, the answer to that is no. So it's the government picking one side of a debate and then compelling you to violate your conscience by speaking a particular message you disagree with. And it sounds like, based on what Walter just said, that we could be looking at a unanimous decision. But listen, I'll take 5-4 right now today, but unanimous is always great. And I will say this also about my friend Walter Weber, who I've worked with for almost 30 years. He is not one that will say often that he thinks something's going to be unanimous. So, Walter, I made the joke, if you can only get 9 votes, but the way you're sounding, maybe we could get 18, except there's only 9 justices. But you feel good about it.
Sounds great.
Yeah, you feel good about it. Logan, what are we hearing online?
Yeah, a lot of people are enthused, I think, from this. This is a question that Julie said. Do abortion clinics, like we brought this up, do they have to bring up adoption even as an option? And we talked about that you don't have to say,
nothing.
Go to this. Do you have to do anything?
They have to do, Walter, there is no law governing what takes. Listen, anytime you try to get regulations on these medical clinics, including informed consent, including, disclosure of the procedures, they don't want to do. There was even a report in the paper today, or it was a tweet I think I saw this morning, that one of the doctors that performs these abortions says that they don't. There was this discussion of if the baby makes noise, does that impact the woman when the abortion taking place? And this particular doctor, at least this is what the report was on Twitter, was that the doctor tweeted out saying, "I sever the vocal cord, so that wouldn't be an issue." So you understand what they're doing here. I mean, understand what's going on here. But, Walter, it doesn't work both ways. I mean, we need to be clear about this. It was targeted directly at the crisis pregnancy centers.
Yes. Well, the California law certainly was. The justices were also, one of the main themes of the argument was, does this apply in both directions? Can the same restrictions be applied to abortion providers as applied to pro-life centers? And if not, why not? And there are 2 really good answers to that. One is, when you're counseling a woman about pregnancy, that's not a medical procedure. You're giving her advice. When you're doing an abortion, that's a medical procedure. Informed consent rules normally should apply. All the things that go into the consideration of that decision should apply. The other thing is, abortion is different. Supreme Court has said this over and over again. It's not like, leave out all the moral considerations. Childbirth and abortion are just 2 ways of terminating a pregnancy, right? That's what Justice Brennan said in dissent. That's not been the Supreme Court majority's position. Abortion is the only thing that takes a human life, and therefore it can be treated differently by the state.
Let's go to Dave in California on line 1. Dave, welcome.
Hey, Dave.
Yes, I think the comparison draws also, suppose you were in a car company like Chevrolet, and you were forced to say, well, you also can get your needs met by Ford and Jaguar and Infiniti and Acura and Kia and so forth, and you're forced to give all their addresses as well.
No, you're precisely correct. I mean, that's what this is. This is the compelled speech doctrine, and in fact, the commercial speech aspect of it came up. Can you imagine telling this car company, no, you have these alternatives as well?
Yeah, that's right. I mean, it doesn't make sense across any other segment of any kind of, whether it's nonprofit or business. I mean, as a nonprofit, do we have to advertise for other nonprofits? Do you have to then say, hey, we do this and so do these people and these people? You could see that this is just an endless cycle, whether or not you're talking about just in one state or how the abortion groups would like this to happen, which is nationally. And it goes back to the idea that the abortion industry on so many fronts believes that they should be treated differently than everyone else in every other sector, so they don't get the same kind of regulations. They don't have to have ambulatory care met at their facilities, even though they perform invasive procedures that can cause the death to the pregnant woman. And so, again, we see it time and time again, treat us differently from everyone else, not just from one specific group, but everyone else. I think the caller made a great point, is that the idea to force these groups into advertising for abortion, in a sense, I mean, they would have to then make these judgment calls of whether or not they would even operate anymore. I mean,
Walter, the fines here are significant. I mean, it's $1,000 per violation after the first violation.
It's not designed to be friendly to pro-life centers. And really what this was a gift to NARAL. NARAL has been targeting pro-life centers for a while, and they came to California and found a willing audience. And I think Justice Kagan, although she didn't mention them by name, was on to that. She said, well, there's a couple ways we can look at this. One is, this is an across-the-board attempt to address informing women, or it's an attempt to target pro-life centers because we think they're bad for some reason.
Yep.
And I think it's that second one. NARAL says pro-life centers are bad. You got to target them. That's what the state has done, and now they're getting called on it.
Well, look, Walter, appreciate your comments on this. Appreciate your insight. Walter Weber is one of our most senior lawyers and really heads up our Supreme Court practice group and does a great job. And Walter's optimistic, so if Walter likes it, I like it. That means it should be a good day when we get that decision, probably the end of June. Thank you, Walter, for being with us. All right, we've got a lot more ahead on this discussion on the life issue, more from the Supreme Court of the United States. We'll be back with more in just a moment.
All right, welcome back to Jay Sekulow Live. This is Jordan Sekulow. The case at the U.S. Supreme Court, the National Institute of Family and Life Advocates versus the Attorney General of the state of California. We filed our amicus brief. We represent 3 organizations in California, pro-life pregnancy centers, that would be directly impacted by how this case turns out at the Supreme Court. We represent Living Well Medical Clinic, Pregnancy Care Center of the North Coast, and Confidence Pregnancy Centers, and at the American Center for Law and Justice. And so we just had Walter Weber on, who was at the Supreme Court, to provide us an update, firsthand update on how the oral arguments went. He feels very good that these laws and regulations that force pro-life pregnancy centers, or sometimes known as crisis pregnancy centers, to advertise for abortion, literally, folks, in the same size font as any kind of advertisement they take out. So if you said, like Walter mentioned, 1-800-PRO-LIFE, and under that, if you did not provide abortion services at 1-800-PRO-LIFE, you'd have to say, we don't provide abortion services. The state does. I mean, this whole long thing that the state does. And here's how it actually reads. All licensed facilities that provide pregnancy services must inform their clients that the state of California, quote, has public programs that provide immediate, free, or low-cost access to abortion. By the way, the Supreme Court taking this up means that this will impact other states where lots of politicians who lead the state get money from the pro-abortion industry who have tried to do pass similar laws. So all of these states will take a second look because they know that controlling Supreme Court precedent, we hope, will make it clear that you cannot do this to pro-life pregnancy centers. It'd be a big victory for pro-life speech, and it may seem absurd, but folks, never forget the abortion distortion. And again, it is something that we deal with every day in federal court with legislation. Abortion, whether it's state, federal, whether it's legislative or judicial, it is always treated differently than everything else, than any other kind of procedure, than any kind of other kind of medical regulation, than any kind of licensing required. They are always treated differently. And so you don't take these as just, well, this sounds absurd. All of the ways the laws work to the abortion industry are absurd. Here's a real opportunity to strike one down that will have national implications. Than Bennett is joining us from our Washington, D.C. office. And Than, you know, too, working on this from the legislative side, we've been seeing this move happen because there is a pro-life president, a pro-life House, and a pro-life Senate on paper. The pro-abortion industry has focused its attention into state politics to get these kind of regulations and laws passed.
No doubt about it. They haven't had any haven on the federal level in the last recent months, Jordan. But look, I would say this, the hypocrisy abounds. And I heard the conversation that you and Jay had with Walter just a minute ago. And I want people to really think about this. When these state-based efforts proceed, there is such a hypocrisy that exists because when you're talking about forced advertising on a pro-life center, the pro-abortion industry comes out in full force for it. But when you're talking about a dangerous medical procedure and the state says, we want to provide the woman that's going to undergo that procedure with access to information about what's going to take place. In fact, we want to give her a free ultrasound to see exactly what it looks like. Jordan, the same exact people that you're talking about come out and viscerally oppose that regulation. So the hypocrisy here is unbelievable.
No, I mean, you bring up a really important point then, is whenever you see legislation put forward by the states that have ultrasound capability, you will see immediately NARAL and Planned Parenthood filing lawsuits saying they shouldn't be able to do that. Why is it that they don't want you to do that? Because then you're actually going to see the unborn child. But they will use any law they can to move their agenda forward. And I think we just have to be clear that's what it is. Logan, let's go ahead and take another call.
All right, Kim's calling in Dallas, Texas. You're on the air on line 3.
Hey, Kim.
Hi.
Hey.
I just wanted to share my story with Planned Parenthood. In 1983, I was married, pregnant with my second child, but we didn't have any insurance, and we were living in a new area, so I didn't know what to do, where to go, what doctor to find. So I saw Planned Parenthood. I thought, oh, I didn't know it was an abortion clinic. And I went in and I had my little boy with me, the one I already had, and told him I believed I was pregnant and could they, help me find a doctor, blah, blah, blah. And they said, no, we only do abortions. You shouldn't have this baby. If you don't have insurance, that means you can't take care of it. You're going to, make your other little boy do without to have this baby. And I looked at him and I said, I don't believe in abortion. I will never do that. And I came in here to get help finding a doctor. And they go, well, we can't help you.
Well, it's because they're in the Kim. Because the reality is, and you've experienced it, is they're in the business of abortion. I mean, that is their industry. They perform over 300,000 of them a year. This is their business. This is their business model, and they are in the business of abortion. Remember the whole controversy over the sale of fetal body parts, which was also a part of their industry. So I think this is, look, you just got to realize that's why I want to hear from people on this, especially women. We really want to hear from you. Those stories like Kim's make a big difference. That's what I call evidence of what's actually happening.
Interesting how that Planned Parenthood, going back to the 1980s, have got their staff as much as possible on message. So even when someone comes in with a child and is looking just for help with finding the right doctor and what services may be available for those women who want to have their child and may not be insurance, they're in a new area, maybe a new job where the insurance hasn't kicked in yet, things like that, and they've moved, that Planned Parenthood, one, says, no, we can't help you, but two, still tries to press you into having the abortion procedure and shame you and say that right in front of your kid, you won't be able to afford your child that you already have if you don't terminate the one that you believe you're pregnant with right now. So while the child is there with the mother, they are on message to get another abortion procedure done, and they don't hide the amount of abortions they do. That's why we call them part of the abortion industry. It's because it's the bread and butter of their business and of their business model.
Not only do they not hide from it, they brag about it. They're proud of it. They think that this is a service that they are providing. I would suggest they are in the business of two things, abortion and politics. But on the abortion business and the business model that you're talking about, Jordan, we don't have to use anything but their own numbers. You guys referenced the more than 320,000 abortions they perform. But let me bring to light for our listeners a couple of other numbers that they themselves report. They report that they refer out for less than 4,000 adoptions. Mind you, they don't do the adoptions themselves. They refer them out for adoptions. And if you extrapolate their prenatal services down to how many prenatal clients they have, Jordan, it's somewhere in the neighborhood of 1,500. So you're talking about 5,000 children brought to term and brought to life in the same period where they are aborting more than 320,000. Jordan, if that is not a business model that funnels to abortion, then I don't know what is.
There is a case at the U.S. Supreme Court on pro-life speech. I think the way we said in our brief that NBC News pointed out and quoted directly from the brief that we filed was clear. No one should be compelled to, quote, act as a ventriloquist dummy for a government-dictated message, and that includes pro-life pregnancy centers.
That's going to do it for the broadcast today. Again, as we come to you each and every week here on the Trinity Broadcasting Network, we're not paying for the airtime. That's because of your support for TBN. We can keep our lawyers in the field working on cases around the globe. But your support of TBN keeps us on the air. I want to encourage you to do that and pray for and support not only the work of TBN and its affiliated ministries, but also our team here at the ACLJ. We'll talk to you next week.